Good evening, everyone, and welcome to Dissecting Monasky v. Taglieri, the US Supreme Court new standard of habitual residence under the 1980 Hague Child Abduction Convention, organized by the Washington Foreign Law Society and co-sponsored with the GW International Comparative Law. I'm Juliana Canet, the president of the Washington Foreign Law Society, founded in 1952 to promote the understanding and knowledge of international legal matter, comparative legal issue, and foreign law. Given the number of participants tonight, you will be muted during our conversation, but you will be able to communicate with us through the Q&A section. Please send us the question in advance to our distinguished panelists. Thank you for those who already submitted their question. We will get to your question toward the end of the seminar. The session will be recorded and posted online for future reference. I will introduce our moderator for this evening, Melissa Kuczynski. Melissa is a private attorney and mediator based in DC. She's also a former consultant for the Hague Conference on Private International Law in Netherlands. She also served as an adjunct law professor at the George Washington University School of Law, having taught its international family law course since 2010. Welcome to all the panelists, and Melissa, the floor is yours.
Thank you so much, Juliana. It's really nice to be here. And it's my pleasure to be able to introduce the two presenters tonight, Richard Min and Jonathan Lounsbury. So just to give you a little background about each of these gentlemen before we get started, Richard is sitting in New York. He is an attorney with Berger, Green and Min, and he focuses exclusively on family law and has significant experience working on these international parental child abduction and international custody and cross-border custody cases. He has extensive trial experience. He goes across the United States in federal courts and has litigated child abduction cases in over half a dozen states here in the US, and also argued before the Second and the Ninth Circuit Courts of Appeals. He routinely teaches education courses and has hosted foreign delegations to talk about the treaty. And he's a fellow of the International Academy of Family Lawyers. And he actually co-authored part of an amicus brief for the Monasky case that was submitted on behalf of the IAFL. And then joining Richard is our very dapper gentleman, Jonathan Lounsbury, who is a very skilled practitioner. He's a family law practitioner in South Carolina. He handles complex family law cases and regularly represents clients in state and federal courts, including in multi-jurisdictional and cross-border custody issues and Hague abduction cases. He practices family law and the use of technology in litigation and trial. He's authored multiple publications on these subjects. He's also a fellow of the International Academy of Family Lawyers, and he's AV rated by Martindale-Hubbell and by Super Lawyers. So I am just beyond thrilled that both of these gentlemen can be here to talk a bit with all of us about this very important case that came out on February 25th of 2020 by the US Supreme Court. So just welcome to both of them. And then I get to give just a very, very brief summary of what this Hague Abduction Convention is. And then I can encourage all of you, just post in the Q&A, post in the chat. I will be monitoring that so that I can help with the flow of the questions for these gentlemen to bring us through all of this. So before we get started, the Hague Child Abduction Convention is an international treaty. The United States itself has ratified that treaty. I believe it was 1988, and these two gentlemen will correct me if I'm inaccurate in any way. And it is a treaty that serves one primary purpose. It is to return a child, return them to their habitual residence. And that's where that term, habitual residence, becomes vitally important. You cannot use this treaty to return a child to anywhere but their habitual residence. So that is one of the key terms of art that needs to be defined in this treaty so that you know what you're dealing with and where you can send the child back to. And therein lies where we get the Monasky decision this year. And that's where we're going to go through that in order to focus a bit more on what habitual residence is, so we know how this treaty can then flesh out. Before I get started, if either gentleman has anything, then I can start into some questions.
Melissa, I do want to just jump on something you said, and although this is really not so pertinent to our conversation. I always found it to be an interesting theoretical argument, but I have heard people make the argument that children can actually be returned to other places other than the country of habitual residence. That the statute does not specifically say that the child can only be returned to the country of habitual residence, even though that is the usual way we look at things. I mean, when we talk about Monasky, we'll also talk about some, I think, misstatements of the law that some of the justices made during the course of those proceedings as well. But I just wanted to throw that out there as an interesting little legal argument.
Yes, thank you so much. So before we begin discussing the Monasky opinion itself, can you talk a bit more, Richard, about the term habitual residence and how it's interpreted in the United States and how it was before Monasky?
Sure. So the United States court system has three tiers. The United States Supreme Court, oversees all of them, or that's the top court in the country. And then we have trial courts, United States district courts, throughout the country. I can't even imagine how many there are. And then we have, is it 12, 13? I think 12 circuit courts of appeals that are intermediate courts that are the first appellate level after the trial courts. So before the Monasky case, habitual residence was defined and interpreted by the various circuits. And there was something called the circuit split. And the circuits were split. The majority view, including where I am in New York, followed the Ninth Circuit, which is out in California, in the West Coast, by focusing habitual residence inquiries, starting with the parental intent. So what did the parents or the caretakers intend the child's habitual residence to be? Along with that, there has to be a change in geography. So the child has to actually be somewhere for there to be habitual residence. And the parents have to, in most situations, intend for that place to be the child's habitual residence. The second test that they have is acclimatization. But that's really in cases where the parental intent is either doesn't exist, or where the child has been in a place, even absent parental intent, for such a period of time that the acclimatization trumps the parental intent. But they always started with parental intent, and that's the majority view in the United States. Prior to Monasky, the minority view, which was followed by the Sixth Circuit, which is where the Monasky case was initially determined, followed the opposite view, which is that the child's acclimatization, or the child's integration into a country based upon their familial, social ties, was the first part of the test. So you look at it from a child's point of view. Did the child believe that that country was his or her habitual residence? And then the second part of that test would be the parental intent. So we'll go more into sort of what Monasky talked about, but in Monasky, they looked at shared parental intent because the child was so young that the child really did not have a point of view as to where his habitual residence was. So that was the circuit split leading up to Monasky. Now there are a couple of circuits that kind of blended those two tests, but generally those were the two things. So they both talked about acclimatization. They both talked about parental intent. Most of the circuits put the priority on shared parental intent, whereas the Sixth Circuit and a couple of others put the priority on acclimatization.
And how did that sort of compare to what other countries had been doing when it came to defining habitual residence?
So it was, and I'll say this to just kind of reduce it to some simplicity, is that in the US, when you look at what Richard was saying, you have the circuit split, you have the shared, and you look at basically the intent versus the acclimatization of the child. The intent is probably more of a parent-centric determination of habitual residence, because you're looking at the intent of the parents and not necessarily what the whole circumstances surrounding the change in geography, as Richard mentioned. In other countries, and they had mentioned this in the Monasky opinion when they cited to an opinion from Lady Hale in the UK, which is a case that we'll deal with later. But in that case, what Lady Hale said is that basically a child's habitual residence is going to depend on a lot more than just one or two categorical determinations. So if we, more than just the shared intent of the parents, it's going to determine on basically what they held in Monasky is the totality of the circumstances. We need to look at facts versus legal concepts. And so in doing that, her opinion was in line with, I think, the Court of Justice for the European Union, a Canadian determination of kind of habitual residence, Australia, New Zealand, some other countries, Hong Kong as well, where they're looking at more of a child-centric, what I would say is a child-centric approach, where they're looking at the child's life and everything that has gone into the change of geography, or the claim that the child's been wrongfully withheld. For instance, in the Fourth Circuit, what we were doing before is we were using a two-part test where we looked at the parties' shared settled intention to abandon a former country. So did they intend to abandon country A to live in country B? And then we looked at whether or not the child was acclimatized to the new environment. How, as Richard said, how integrated are they familiarly and socially into where they are now? That again is going back to that kind of parent-centric approach. So the world kind of as they do outside of America look at children and the children's rights versus the parents and the parents' rights, but that's a whole nother topic of conversation. So
Yeah, I mean, I'll just jump on that and also mention that at least here in New York, Second Circuit cases, there had been a shift, I'd say, over the last 10 years or so against this rigid approach about the shared parental intent into more of a liberal interpretation based upon the plain meaning of those words, the words habitual residence. So there's a string of cases that talk about habitual residence as meaning the ordinary or customary residence of a child. It was more of a subtle shift than anything else, but courts started using that phrasing a lot more. And I think we'll see that sort of reverberate in the Monasky decision as well.
So I'm going to keep moving, but I do see the questions that are coming in, so I'm monitoring that for everyone. Okay, so we have a circuit split in the United States. So of course, that hopefully means the Supreme Court will resolve that. And that certainly seems to be, hopefully, maybe, what the Supreme Court did in the Monasky case. So this was the fourth US Supreme Court case as it came about for the 1980 Hague Child Abduction Convention. Can someone give me a bit of overview of what were the facts in Monasky versus Taglieri, so we have some foundation to talk about it?
So the facts were, and I'll give kind of a very short, and if you'll bear with me, I'm going to get to the page in the opinion, so I've set it straight. But the facts were you had a couple. One was a U.S. citizen, one was an Italian citizen. They married in 2011. They moved to Italy, and in 2014, Mrs. Monasky became pregnant with their child. She was not happy with the relationship. She, according to the facts and the opinion, she was talking to U.S. divorce lawyers, trying to figure out how to move back to the United States, presumably. Their daughter was born in 2015 in Italy. And then shortly thereafter, she returned to the United States. Mr. Taglieri instituted an action for return in the district court in the United States, in the district court for the Northern District of Ohio, for return under the Hague Convention. The court ordered the return, and they brought an appeal to the Sixth Circuit, and they upheld the appeal, and then we worked our way up to the Supreme Court for them to have to weigh in on what Richard was mentioning earlier is about the circuit split. How do we look at this term of habitual residence?
Yeah, I think the important parts of the case are that, at least around the time the child was born and in the months the child was living in Italy, it was a very turbulent relationship. There were a lot of allegations of domestic violence. Certainly there was a lot of discussion about separating, as Jonathan mentioned, the mother had sought out a divorce lawyer in the United States and also talked about moving back to the United States after the child was born. So I think that's really the important aspect of the case.
So what issues were then before the case?
So the main issue, at least when it got to the Supreme Court, dealt with two things, but the main reason we're here talking about the case is about the interpretation of habitual residence, specifically for infant children. Now, throughout the Sixth Circuit proceedings before Monasky in the Supreme Court, the fundamental question was, for children this young that are unable to acclimate to a foreign country, does there need to be an actual agreement, a subjective agreement, a meeting of the minds between the two parents in order to create the shared parental intent necessary to have an habitual residence? That was a springboard, ultimately, for the US Supreme Court to interpret habitual residence more broadly, which is what they ultimately did. Let's say what we think they ultimately did, because I think some courts don't believe they actually did that. But in the beginning of the Monasky decision, they said their issue was to determine and to resolve the circuit split about the definition and interpretation of habitual residence, more broadly than the question that was really presented, which focused on infant children and the necessity for a subjective agreement. The second thing is the standard of review. So there was a circuit split also about how appellate courts can review trial court's findings on habitual residence. Internationally, courts generally view habitual residence to be a determination of fact. In the United States, there was a split. Some said it's a question of pure fact. Some said it's a mixed question of fact and law. Some people said that the standard of review by appellate court should be clear error, which is the standard of review for factual determinations. And then some said it should be de novo, since it was also a legal question. De novo meaning the appellate courts could take a fresh look at it and reanalyze the habitual residence interpretation or determination.
So what did the court, just in very basic recitation, what did they decide with regard to habitual residence?
So the court, SCOTUS, kind of gives a new definition for habitual residence, or a new way to determine habitual residence, and it was to look at the totality of the circumstances. It was going back to what I was kind of talking about earlier, where we've shifted from more of a parent-centric shared intention, which is one of the factors that they addressed in Monasky. The district court in Monasky held that the parents had a shared intention for everybody to live in Italy. So basically there was a shared intention for the child to have habitual residence in Italy, even though she was there for a short time and then came to the US. But in short, simple terms, we're now looking at how to determine habitual residence by looking at a totality of the circumstances.
And what was the decision with regard to the standard of review?
The standard of review is they also, I guess, cleaned that up and saying that we're now looking at a clear error. So we review the appellate court, whoever's reviewing the decision is going to look to see if the trial court made any error of law, made any error in not law of law, but any error whatsoever in their determination of habitual residence. So we no longer have that mix of is it a factual determination, is it a legal determination, or as I dealt with in the Fourth Circuit, a mix of fact and law. So
they're saying essentially it's mostly fact. It's a clear error. So with the totality of the circumstances standard, it seems like they're looking primarily at very fact-specific situations.
Right. So I think I'm sort of struck upon the subjective agreement question that was posed by some of the amicus briefs. I know we'll sort of get into more detail about that later, but I do want to make it clear that for people who really don't understand habitual residence interpretation, there is a distinction between shared intent and subjective intent. And sometimes that's not very clear, because when you talk about parental shared intent, one might assume that it means that the parents subjectively intended for a child to be residing in a particular place under particular circumstances, but that's not always true, because the case law is clear that when you're looking at a shared intent, you're looking at not only what they subjectively intended, but also what actions they took to demonstrate that intent. So if you bought a house in a new country, if you got a new long-term job, if you started going to church in that country and started enrolling your child in the school in that country, those are all actions that demonstrate a person's intentions. A subjective intent is a much stricter standard, a much stricter question, because it really requires a judge to get into that person's mind and determine whether or not this person truly intended unequivocally to reside in that country. And clearly in Monasky, one of the reasons they were appealing on that issue is because the mother did not have an unequivocal intention to reside in Italy. The mother clearly was questioning that and making plans to return to the United States and contacting divorce lawyers in the United States. So clearly she did not have a subjective intent to reside in Italy, at least for the long-term future. So the Supreme Court did knock down that requirement. One of the reasons they did so is because Justice Ginsburg, who wrote this decision, said that it would leave a lot of children without protection under the convention, because it would lead to a lot of decisions where there was no habitual residence, which is something that one of the amicus briefs did argue for, and something that I know people have discussed before.
Right. I mean, in the opinion, the court expresses the fact that an actual agreement between the parents is not necessary to establish, in this case, to establish an infant's habitual residence. And a lot of times when we're in court arguing that, you may have the smoking gun, which is the email that says, yeah, I agree to go live in wherever for however long, or you might not, like Richard said. So when you're dealing with the shared or subjective, it's a lot harder to prove it's very hard either way to prove somebody's intent or lack thereof.
And there was a question in the Q&A, as many children may be too young to give an opinion as to which country they really belong to. Would it be fair to say that in practice, the child's habitual residence is often the judge's opinion or determination on this issue in preference to the parental intent?
I would say, go ahead, Richard.
No, I'm trying to understand the question. Is the questioner asking whether or not judges sort of not ignore, but use the preference of the parental intent because sometimes children are too young so that it's easier to focus more on the parental intentions? I was a little bit confused by the wording towards the end.
Then maybe let me answer what I think the question is, and you'll tell me if I'm wrong, because I know you will. But I think what the court tried to do in Monasky is address this issue, right? Is it the judge's job to figure out what everybody's doing? Or if I look at everything, if I look at the totality of the circumstances and I come at it from a pragmatic and practical view of these are the steps, like Richard said, that people have done: bought a house, got a long-term job, attended church, enrolled children in school, became part of the community. Do all of these signs point to, like the magic 8 ball, if you shake it up, do all of these signs point to yes? And I think in adopting the totality of the circumstances standard for looking at a child's habitual residence, it's their way to tackle that issue that's raised in the question. Whose intent are we looking at, and whose preferences are we looking at? Is it just the judge saying, I guess this is what it is, or have they been presented with enough facts? Because prior to Monasky, even though there wasn't a totality of the circumstances standard, your job as a litigator in trying these cases was to either show the court that the parties had all of these facts that show that there was no intent between the parties to reside in the new country, or there was all of this intent for the parties to reside in the new country. In some instances, it was very hard, and it's still going to be very hard going into the future, but at least you're out of the guise of trying to shoehorn it into either a very strict interpretation under the subjective intent or a kind of broader shared intent. You're not so much relying on what the parties want to do, and you're not going to rely on the child because, again, the child's young. And all the cases I've tried, I've never had a child testify. I've had cases where the court will talk to the child privately, but I don't know how much that weighs on anything because they know that they're talking to a child. Does that make any sense, Richard?
Yeah, I mean, again, if the question is limited to young children, children that are too young to offer their testimony, or even directly or through a guardian ad litem, ultimately, I do think, it really is going to come down to the parental intentions, right? I mean, I think no matter sort of where you land on the Monasky decision, that has generally been the rule of thumb in habitual residence cases. So I don't think that's anything new.
Right.
My takeaway from the question was whether or not the judges sort of, it's really just their discretion, right? I mean, how much discretion do they have to insert their opinion over maybe the facts of the case in a way? And that's something we'll sort of go into, I think, when we talk about the legacy of Monasky.
So now judges can look at everything, the totality of the circumstances, any fact, any issue, intent, acclimatization, anything, immigration, the child, what they're saying. How do the judges actually weigh these facts?
So I'm going to talk about a few of the facts that they put forth in their decision, because really this is going to come down to one of my big critiques of the decision, which is we actually don't know. I mean, we don't know how they weigh certain facts, and we don't even know what facts the court should or could use in their, totality of the circumstances test. But here are some of the things that Justice Ginsburg mentioned in the decision. So she talked about, where a child has lived in one place with her family indefinitely, that place is likely to be her habitual residence. But suppose, for instance, that an infant lived in a country only because a caregiving parent had been coerced into remaining there. Those circumstances should figure in the calculus. So, for example, if someone's a victim of domestic violence and there's coercive control, and the victim has been coerced into living in a particular country against his or her will, that could be a factor. Even though she's been living in that country and all of her intentions show that she is planning on living in that country, if those are a product of undue influence or coercion, then that certainly is a factor that can lead to habitual residence determination. The court also wrote that a mere physical presence is not dispositive in an infant's habitual residence, meaning that just because a child is located in a country doesn't mean that that's the child's habitual residence. So other facts that the court pointed to is, have the parents made their home in that country? If there's an actual agreement, that's also a factor, not something that the court does not require, but a fact that the court can use. The court specifically said that there are no categorical requirements for establishing a child's habitual residence. That, again, goes to my initial point on this question, which is there are no requirements. There's no factors. There's no, here's a list of all the factors you can use in determining habitual residence, which is one of the more frustrating parts of the case.
I think footnote 3 is the closest that it came to that. And that was just a citation to the Federal Judicial Center's publication, where it gave things like a change in geography, passage of time, age, immigration status, academics, social engagements, sports, connections, language.
Right.
That's, not exhaustive and not illustrative.
Right. And, going to one of the questions that we got before the program started, I think earlier today or yesterday, someone asked about, the child's ties to the primary caretaker. And Monasky actually talked about the McCready case in the UK, McCready versus Chaffee, where the facts of the case, I'm not sure if it was a UK case, so I apologize. The fact of the case was that the infant was looked after by the mother. So it was necessary to assess the mother's integration into her family and social environment in the particular country. And the Monasky court said that that's a factor that the court could take into consideration. So, they mentioned a lot of factors. They didn't say that this was an exhaustive list. They, in fact, said it wasn't an exhaustive list because they said there are no categorical requirements for establishing habitual residence. They gave no advice as to how they should weigh the relevant factors.
Right. And
here
this
we are.
decision came down on February 25th, and probably 2 weeks later, courts, for the most part in the US, shut down. And so,
Right.
so we are now in that place where we're asking ourselves, well, how are courts actually applying this standard? And we're slowly starting to see some cases. So are you seeing any trends in how the court is actually applying this totality of the circumstance standard?
So what I've seen, I think what Richard has seen, we've talked about this a fair bit over the last couple weeks and months, is that it is the same old dog by a new name. They're using the standards that they were used to using beforehand, but they are lumping it under the totality of the circumstances. I mean, the way that the court, Richard gave you some items that there are listed in the opinion of what the court may consider, but they're very thorough and detail-oriented instruction as to how to use the totality of the circumstances is a fact-driven inquiry that must be sensitive to the unique circumstances of each case. So, what's the court going to do? The court's going to say, well, okay, in the Fourth Circuit, we have is there a shared settled intent? Well, that's one of the factors I can consider that's relevant. All right, has the child become acclimatized? And I'll look at all of these things, academic activities, what's the immigration status, what are the social engagements? Okay, those are all factors I can do. And I'll just say that's the totality of the circumstances, that the child's either habitually resident in another country or one of the defenses applies.
Well, here's the thing. For the past 25 years, the circuits have done a pretty good job within their circuits of defining habitual residence. If you went to the Sixth Circuit, if you went to the Fourth Circuit, you had a robust case law that defined habitual residence in a variety of different circumstances: young children, older children, agreements, temporary work reassignments in foreign countries, immigration status cases. So you really could point to the history of the case law within that circuit to make an argument about the habitual residence for your particular case. So the problem is, after Monasky, because there was really a lack of clear direction, coupled with the fact that these judges who handle Hague Convention cases are typically not experienced in this field. It's not like you go into a Hague Convention court and the judge says, okay, this is my 75th Hague case this year. It's normally going to be your first, second, third, case that they've ever handled in their career. And they don't handle any other family law cases other than Hague Convention cases. So it's not like they're handling custody cases or talking to children typically, or dealing with guardians ad litem, or dealing with these types of issues aside from Hague Convention cases. So they get these cases, they don't really know what to do with them. They have a robust skeleton of analysis, habitual residence analysis that they can lean on within their circuit. And then Monasky says, well, you're free to use a totality of circumstances for your particular case, plus the appellate standard review is going to be deferential to you. So the federal judges typically, from what I've seen, are relying, as Jonathan has said, on the prior circuit interpretations. And it's really not surprising that they're doing that, because I understand from a judge's perspective, instead of looking at international cases and looking at cases from different circuits, and then having to spend all this time really trying to figure this out from scratch, they just rely on the last decision made within their circuit that is sets the precedent, and they say, oh well, I've looked at all the factors, and in this case, parental intention is the factor that I'm going to give most weight to. And trust me, I looked at acclimatization, and I looked at coercion, and I looked at conditional intent, and I looked at the relationship between the child and the primary caretaker, but I'm giving more weight to parental intent, and here's my decision. And the appellate court is not going to do anything about it.
So you mentioned that these judges aren't used to family court type cases, and there was a question about the child's best interest and how that might factor in a determination of a habitual residence.
So I would say this, I think I was going to raise that issue following up with Richard's comments. I think it's important to understand this, that these cases are bench trial. These litigations are bench trials. There are no juries. So your jury, your fact finder is your judge. So if we go back to the question that we had earlier, Is it the judge's preference? Well, it's not really the judge's preference. It's what the judge is determining to be the relevant facts, and now determining to be the relevant facts to the unique circumstances of the case under this totality of circumstances standard. But they're the jury. So you will present all your evidence to them. You'll make all your arguments to them. They're going to determine the credibility of the witnesses and the credibility of the evidence presented to them. In doing that, like Richard said, if you're in federal court, they do not deal with family court cases. So they're not going to deal with the best interest of the child. And the one thing to understand, we kind of touched on it briefly about the 1980 Hague Convention cases, is these cases literally limited to one issue. And I know people say this different ways. The way that I look at it is it's a jurisdictional issue. Where is the underlying custody case going to be tried? If there hasn't one already, been filed in the country you're in, because sometimes people file multiple cases. But essentially, what is the habitual residence of the child, so that we know going forward where that case is going to be held? Is it going to be held here in the United States, or is it going to be held in the country that the left behind parent is asserting is the habitual residence? And in doing that, the court's not looking at these totality of the circumstances or these facts from the standard of, is it the best interest? Is this in the best interest for the child to stay here? Is it in the best interest for the child to go back? They're just looking at it to say, are there enough facts to add up for me to say, like Richard said, I'm going to use my standard that I've had for years that's robust and gives me a definition of what my circuit believes habitual residence to be. And are there enough facts there on top of that for me to determine whether or not the child's habitually resident in this other country? It's a very niche area of the law. It's a very niche area of litigation, and it's just like everything in family court. It's very gray. There's no way. I mean, in South Carolina, we do not have a definition of what's in the best interest of the child, right? It's like the old Supreme Court definition of pornography. The judge knows it when they see it. So what's going to be determinative of the habitual resident of a child in the totality of circumstances case? Probably going to be the same thing. They're going to know it when they see it.
Well, let me say this about the best interest question, because, typically as a practitioner, the general way these cases work is that if I'm representing the left behind parent, the plaintiff, the petitioner, I'm trying to rush this case to trial. I'm trying to streamline the issues, make this a jurisdictional case, and have a decision within a few weeks. If I'm representing the person who allegedly abducted the child, I'm trying to delay the proceedings, draw it out, and make it about the child and make it about the best interest of the child, right? Courts have never, the Hague Convention says that the court is not allowed to make a child custody determination. That's true. It doesn't really say that the court cannot consider the best interest of the child in some aspects. I mean, of course they do in many ways. When they're talking about an Article 13B grave risk defense case, they're considering the best interest of the child. When they're talking about an Article 12 well-settled defense case, they're considering, the welfare of the child. And although we'll talk about the amicus briefs later on, the International Academy of Family Lawyers, where I contributed part of the brief, argued one of the reasons that the Supreme Court should adopt a parent-centric approach is that a child-centric approach, number one, leads to a delay in proceedings because you need more fact witnesses, you need more evidence, but also gets into the realm of a best interest analysis. Because if you're focusing on acclimatization and the child's life in a particular country and a child's ties to that particular country, then you're sort of delving into really custody aspects. I'm not saying I agree with the assertions of the International Academy necessarily, but that was one of the arguments that they made, and they were actually the only amicus brief that made this argument. The other thing about best interest, and I know the second time I'm harping on this, but if you are analyzing the relationship or the habitual residence of the primary caretaker as a factor in determining the child's habitual residence, then you do have to, by extension, figure out who is the primary caretaker, right? I mean, that's one of the sort of drawbacks of using that as a factor. Because if you say, well, the mother is the one who's always been taking care of the child, she has no connection to this foreign country, she came here because of the husband's job, there was domestic violence, she wants to go back, the child's 6 months old, the child has only been in her care. Therefore, through the eyes of the mother who has no connection to this foreign country, the child's habitual residence also should not exist or have ties to that foreign country. You do have to, by extension, get into a best interest analysis. So I don't think this is a black and white issue where you say that best interest really never plays a part. There are ways and mechanisms in which you can introduce best interest.
I think best interest is almost a loaded term. As family lawyers, we use best interests when we're resolving custody cases, and this isn't a custody case. So I think when someone uses the term best interest for a Hague abduction case, what they really mean is what you said, Richard, the welfare of a child's well-being more than what we would think of as the legal standard of best interest.
Right.
But I mean, I think it's distinguishable though, right? Even what Richard's saying is you could call it that, but what I would call that is a grave risk defense or a well-settled defense. Because when you start saying best interest, you're causing the court to do exactly what it's not supposed to do. Even though I don't agree that, someone who's the primary caregiver, what their actions are should be determinative of what the child's actions are, regardless of the age of the child. That right there is going to be a well-settled defense if it's applicable, or if you're in a place where acclimatization is a factor to consider, then that's going to be the argument. I get what Richard's saying is that you are looking at the best interest, but for me, you're not. Because when I say best interest, when I go to court here, when I go to family court, the court's going to decide the entire case on what's in the best interest of the child. Determining what country the child was habitually resident in doesn't have to deal with what's in the best interest of the child, because they're going to go wherever they're going to go after they get done with district court, and it's whatever order they get, return or stay, to deal with that issue.
So I'm recognizing time limitations today, and I noticed that Richard and Jonathan, you mentioned the amicus brief several times and that you would get back to it. So I wanted to focus a little on that particular issue, and then we can certainly circle back if there are other questions. There were several amicus briefs that were filed with the U.S. Supreme Court. A lot of them took very different views. In fact, the view that was adopted by the court seemed to be the one that was propounded by the U.S. government. And they seem to be the only one, maybe except for one that was filed by Reunite in the United Kingdom, that took that type of totality of the circumstances type of standard. Do you have any opinions on these briefs and the standards and the opinions that were put forth?
Well, I hope that there are no authors or contributors to those briefs in the, watching this program. I certainly have opinions of the, there, like you said, there are a variety of opinions offered in these briefs. So certainly I can't agree with them all. I will note that the Reunite brief really did not express an opinion. It really just talked about the history of the cases internationally, focusing on the European and UK cases, and how the European EU really shifted their focus into a totality of the circumstances test. So they really didn't advocate, although, I mean, if you read between the lines, then I think you could make that argument. The International Academy, like I said, of which I contributed, made the argument that the majority circuit interpretation in the US should control, which is focus on parental intent, because they were really the only brief, I think, that really focused primarily on the purpose of the convention, the goals of the convention, and the impact of a decision by the United States Supreme Court. And they argued that if you focus too much on acclimatization and a child-centered approach, then the cases are going to take much longer instead of the aspirational 6-week period. Parental intent acts as a deterrence because you can kind of get around the intention of the parents by setting up acclimatization. And one thing that I found somewhat persuasive was that there's already a well-settled defense if a case is not filed within a year, meaning that if a case is filed after a year, then the child's assimilation or integration, to use a better, not so great a term, but acclimatization, so to speak, into the country where the child was taken could override any other factors. That was an interesting argument, because I did think it was very unique. Sanctuary for Families, a domestic violence victims organization, really focused on this subjective intent. argument that the U.S. Supreme Court rejected. Also, the U.S. government rejected in their brief. And their focus was really on protecting victims of domestic violence. And in this case, although the domestic violence was not an issue before the Supreme Court, which Justice Ginsburg at oral argument was actually quite surprised about. And I do think that was a misstep during the appeals process. But putting that aside, the Sanctuary for Families was arguing that in order to protect victims of domestic violence, you had to have a stricter standard of parental intent, because otherwise, victims would be coerced in staying certain places. They would not be able to leave, and they'd be forced back into jurisdictions and countries where they would be further victimized. And then Frederick Cox also submitted a brief, and I can't say exactly what their argument, but they did focus a lot about the marital instability and difficulties they were having. I think their main argument was that there was no habitual residence in Italy, that the marriage was so unstable that, and the child was there only for such a short period of time. There was clearly an intention for the mother to leave at some point, that this is one of the rare circumstances where a child does not have a habitual residence.
Must there be a habitual residence?
I mean, I still don't know, because really the Supreme Court in their decision said that using the Sanctuary for Families approach and using the subjective intent approach would lead to a lot of children not having an habitual residence, which goes against the purpose of the Hague Convention. But that falls short of saying clearly that each child must have at least one habitual residence. They didn't say that. They kind of just said that children should not be left without a habitual residence as a goal. Not saying that,
under this totality of the circumstance, do you think that a child could be returned to a country, so returned to a habitual residence where they've never lived?
Oh, that's an interesting question. Jonathan, do you have a answer for that?
I do. And that'll bring us back to the Lady Hale quote that they relied on, which I see there's another question in there that kind of will center on this too, about whether or not we're closer to the European courts now with the totality of circumstances. But the case that they cited from Lady Hale involved those exact facts, and involved England and Pakistan and a tumultuous relationship between a married couple. The husband was, I think, one of 5 or 6 siblings, and he had been born in England. The wife, everybody lived in England. They had 3 other children who were born in England, so they're English and Pakistani citizens. The husband went to Pakistan and somehow ended up getting the wife to come there too, and then wouldn't let her leave. And while she was there in the country, she became pregnant with a child who was later born in Pakistan, had never been to England. And the English courts, using this kind of totality of circumstances, determined that there, as Lady Hale said, there are numerous factors that the court has to consider, with the purposes and intentions of the parents being merely one of the relevant factors. The quote that I think will answer the question is, the essentially factual and individual nature of the inquiry should not be glossed with legal concepts. So do you have a legal construct like habitual residence that should just be done, determined by legal concepts? Or do you have a legal construct like habitual residence that's going to be underpinned by factual constructs, which I think is the case. Melissa pointed out a case to us today that was handed down by a court of appeals in Florida.
The district court in Florida, I think.
Right,
district court in Florida, right, where their determination of a child who was born in the United States should be returned to Brazil was a little bit different. And that centered on what Richard and I have been talking about beforehand, is they kind of relied on the lower court relied on the prior standard. And I think they made the decision maybe pre-Monasky, but that there was a shared intent that the parties would be in the U.S. for a very temporary period of time. They did not intend to reside here permanently. And even though the child was born here in the United States, that was one of the reasons they came, so the child could be born in the United States and end up having dual citizenship, that they always intended to go to Brazil. And so that even though that child had never been to Brazil, it was ordered to be returned to Brazil as a result of the proceedings. So, it sounds like, something that shouldn't be the case. But it touches on what Richard said. Should children not have habitual residences? I think, under the standard that we have now and kind of the way that the courts look at it, is you may not end up in it with a case where there's no habitual residence. It's probably going to be either A or B.
Yeah, a couple things about that case and about this question. The Moses Court in the Ninth Circuit, when they first really set forth the parameters for interpreting habitual residence, talked about the shared parental intent. The second prong to that test was a change in geography. So essentially, a shared parental intent means nothing if the child's location has not changed, right? If you say, all right, we agree, we're going to move the family, we're living in the US, we're going to move to Canada forever. We're going to sell our house, we're going to do everything, we're going to enroll this child in school, we picked a school, put in down the down payment, but then we actually never move. Then the habitual residence could not have shifted according to the Moses Court, right? And that's been followed by the majority of circuits in the US prior to Monasky. This Florida case is different. And now there's actually an appeal going on in the 10th Circuit. The facts were fairly similar in the sense that the parties were in a relationship in Brazil. The mother got pregnant. Mother came back to the US where she's from, gave birth in the US. Father brought a Hague action in Oklahoma to return the child or children, I'm not sure if it was twins, back to Brazil, and they lost. Essentially because the children had never been in Brazil before. Now that's on appeal. So this is going to be an interesting question. If you're talking about totality of circumstances and you don't have at this point, technically speaking, a change in geography litmus test anymore, that you don't need a change in geography as a requirement for habitual residence, then perhaps you don't actually have to set foot in a country for there to be habitual residence.
And I think Justice Ginsburg did say in this, when she was defining the totality of circumstance, she said it is typically where the child is at home. And typically, if you haven't lived there, you're not at home there. With the 2 minutes that we have left, do you think that it's been resolved? I mean, do you think that we're in a better place right now with the new opinion and standard?
I think we're in an interesting place. I think,
so like a lawyer,
putting COVID aside, I think we're really in an interesting place because it's like getting 2 bites of the apple. Okay, you're no longer maybe hamstrung to just using the standard that your circuit has. You can now argue all these other things that you may not have been able to argue before. Likewise, someone who may not be able to have argued a well-settled defense because it's short of a year when the action's filed, they get to argue stuff that they weren't normally would have probably been able to argue before under this totality. These are all the facts that you need to look at. I don't know that it's not the answer to the $64,000 question, but with these cases, I don't know that you'll ever get the answer to the $64,000 question because the question changes with each case.
I think we're going to need to reserve the answer to this question to the future, in the sense that this is still developing. Right now, it's still a fairly new decision. There've only been a handful of cases that have been, interpreted habitual residence since Monasky. I do think, my bit of advice for everybody or anybody who's in this situation or as a client in this situation is you really need to get an expert Hague litigator on your side, because it's incumbent upon all practitioners to know not only the cases in their circuit, the cases in other circuits, the cases in international courts, all the factors that have ever been discussed in any habitual residence determination. Because if you're really truly looking at a totality, like Jonathan said, you can bring in anything that you believe to be relevant and then let the judge determine what they believe to be relevant, but you can't limit yourself. And a lot of practitioners will be self-limiting in the knowledge that they have and the experience that they have. So I think that it is really important to either, keep going to these CLEs, keep doing your research, bring on an experienced litigator to help you through these cases. One thing I would focus on in terms of the future and the ramifications of Monasky is we have to have a uniform interpretation. The purpose of having the Supreme Court take on Monasky and make this determination is to provide some guidance and a uniform interpretation of habitual residence throughout the United States that's more in line with the rest of the international legal community. So I think it's important that practitioners really urge that from judges, that judges not rely upon what is comfortable or easy for them, but that they strive for the uniform interpretation, and that we can sort of move to more and more predictable outcome, because I think predictability, as the International Academy argued for, is important because it acts as a deterrent if you have some sort of predictability, and it makes it easier for litigants and practitioners to litigate these cases.
So I think that brings us to the end of our hour. And I just want to thank Richard and Jonathan for joining us, and I'll turn it back over to Juliana.
So thank you to all. It was really fascinating. It went very quickly. For the audience, thank you for joining us. It would be recorded and put on the website, and follow us for the next seminar. Anti-corruption is coming up on December 10th. So come on board and follow our activities. Thank you. Good evening.
Thank you.
Thanks. Happy Thanksgiving to anyone who celebrates.
Thank you.